Good morning, class. Settle down, please. Let's get right into it. Welcome to this critical, absolutely vital, exam-focused explainer module. I'm your professor, and today we are tackling a foundational pillar of Indian constitutional law. We are breaking down question 18, Safeguards to Civil Servants and the Doctrine of Pleasure. Now listen carefully and take meticulous notes because mastering this exact question with the precise structure I'm about to give you is going to secure you maximum marks in your KSLU final examinations. Do not deviate from this framework. Understood? Good.
Right, let's look at the agenda. Section 1 is the Introduction to Civil Servants. Section 2, the Doctrine of Pleasure. Section 3 covers Article 311, Constitutional Safeguards. Section 4 will be the exceptions to those safeguards. Section 5 are landmark case laws. And finally, Section 6, Conclusion and Exam Strategy. Let's move.
Section 1, Introduction to Civil Servants. Now, I instruct you to literally copy the structure I just gave you onto the very first page of your answer scripts. Laying out that rigid structure right off the bat, it proves to the KSLU evaluator that you know your Bear Act inside out. Anyway, start your answer booklet with this exact heading. Civil servants hold office under the doctrine of pleasure, but are granted constitutional safeguards to protect from arbitrary dismissal and ensure fairness. Make sure you underline it neatly. You see, structure is absolutely everything in administrative law. You must deliberately dissect how this dual concept is the foundational premise of your entire 16-mark answer. On one hand, you have the state's power, which is the pleasure. On the other, the employee's shield, the constitutional safeguards. That tension, that is exactly what you are being tested on. Moving on, Section 2, Doctrine of Pleasure.
Underline this heading in black ink. Make it pop out for the examiner. Meaning, derived from English law, signifies that civil servants hold office during the pleasure of the president or governor. Now, what is strictly vital here? You absolutely must mention its origins in English common law, where servants held office during the pleasure of the crown. But more importantly, you must write during the pleasure of the president or governor in strict quotation marks. It's mandatory for scoring full points, okay? It proves to the examiner that you are citing the constitutional spirit perfectly.
So, Article 310. The president for the union or governor for the state can remove a civil servant. However, this power is not absolute and is subject to constitutional safeguards. Now, Article 310 is your anchor provision. Explicitly call it out. But heed my warning here, class. Never, ever write that the president's or governor's power is unchecked. No. The scope in India is strictly limited. The executive cannot just act on a whim. That power is deliberately and carefully restricted by our Constitution.
Which brings us to Section 3, Safeguards to Civil Servants, Article 311.
This right here is the beating heart of your exam question. If Article 310 is the sword of the executive, Article 311 is the constitutional shield. The safeguards are no dismissal by subordinate authority, right to reasonable opportunity, and the inquiry requirement. I want to aggressively emphasize that first point. A civil servant literally cannot be dismissed or removed by an authority lower than the one who appointed them. If they are, the dismissal is void ab initio. Period. And as for the right to reasonable opportunity and the inquiry requirement, well, these aren't just mere statutory rules. They are the very pillars of natural justice embedded right into our Constitution.
Now, how exactly is this opportunity realized? You follow these steps to the letter in your answer. Step 1, charges must be communicated. Step 2, opportunity of being heard must be given. Step 3, proper disciplinary inquiry must be conducted. This procedural flowchart is what guarantees the employee's absolute right to defend himself. Before any dismissal, removal, or reduction in rank, this sequence has to be satisfied to meet that reasonable opportunity mandate. If you skip even one step in your answer, you are losing marks, plain and simple.
Next up, Section 4, Exceptions to Safeguards, Article 311, Clause 2.
Class, pay close attention here. This is the twist in the law. KSLU evaluators are actively looking for Article 3111, Clause 2. Including it shows you understand that no right is truly absolute. The safeguards do not apply in these three exact scenarios: security of the state, conviction on criminal charges, and when it is not practicable to hold an inquiry. Now, why on earth does the Constitution strip away these hard-earned safeguards? Well, it's because public interest and national survival always supersede individual procedural rights. If an employee is a threat to the security of the state, holding an inquiry is dangerously counterproductive. I demand rote memorization of these three specific points. Write them down bullet by bullet.
All right, Section 5, Landmark Case Laws. Case 1, Shamsher Singh versus State of Punjab. Put your pens down for a second and just listen to me. Referencing judicial interpretation is exactly what separates a top-tier first-class answer from a mediocre one. If you want that top grade, you have to show how the Supreme Court actually interpreted these bare acts. For Shamshir Singh versus State of Punjab, I'm ordering you to draw a physical box around the citation in your exam booklet. A box citation immediately catches the examiner's eye. Now, this case deals with the judicial interpretation of Article 310, evaluating if the doctrine of pleasure is absolute. In this landmark case, the background revolves around the Supreme Court deeply evaluating whether the executive power under the doctrine of pleasure could be exercised arbitrarily. The court was rigorously testing the constitutional limits of the state's power to dismiss someone without cause.
And here is the quote. President/governor must act on the aid and advice of Council of Ministers. That right there is the final ratio decidendi of the court. The crucial takeaway is that this legally binds the executive head. The president or governor can't just wake up one morning and dismiss a civil servant on a personal whim. Their discretion is severely limited by the cabinet's advice. It proves that the executive head is a constitutional authority, not a monarch.
So, the relevance. The Supreme Court held that the doctrine of pleasure, Article 310, is not absolute. This is the absolute relevance of Shamshir Singh to the main legal provision. You must explicitly write why this matters in your exam. And it matters because it cements the legal concept that constitutional limitations bind the doctrine of pleasure in India, ensuring it can never be exercised arbitrarily.
Moving to Case 2, Union of India v. Tulsiram Patel.
This right here is the second crown jewel of your 16-mark answer. Underline this case name so the evaluator literally cannot miss it. You use this case specifically when you are discussing the exceptions under Article 311, explaining Article 311's safeguards and the application of exceptions to constitutional protections. The facts of this case dealt heavily with the severe tension between protecting a government employee's rights versus the practical, overriding realities of state security and public interest. The court had to thoroughly explain how the safeguards operate when the exceptions are actually triggered.
Here is the quote from the judgment. Inquiry can be dispensed with in certain cases, e.g., security of state. This ratio decidendi gives real teeth to Article 311, Clause 2. It brilliantly illustrates how the state is legally allowed to entirely bypass principles of natural justice and discard the inquiry requirement when it is absolutely necessary for the security of the nation.
And the relevance? Legally validates the exact exceptions where an employee loses their right to a disciplinary inquiry. Let me advise you very clearly on this. Linking Tulsiram Patel directly to Article 311, Clause 2 is a guaranteed mark-scoring strategy. It shows the evaluator that you don't just know the exceptions exist, but you actually know the supreme judicial authority that enforces them.
Finally, Section 6, Conclusion and Exam Strategy.
We have arrived at the final concluding paragraph of your answer script. Listen, a strong summary leaves a lasting impression on the KSLU evaluator. Do not just stop writing abruptly. Tie the concepts together beautifully. Note these points. Protects civil servants from arbitrary action, ensures fair procedure, maintains efficiency and morale in administration. These exact points must be woven seamlessly into your concluding statements. It demonstrates a holistic understanding of administrative law. You are showing them that you understand this law isn't just theory. It actually maintains the morale and efficiency of the entire governmental machinery.
In your conclusion, you need to clearly contrast administrative control with constitutional protection. On one side, you have the doctrine of pleasure under Article 310, representing executive authority. On the other side, the necessary safeguards under Article 311, representing civil servant rights. You see, the Indian Constitution brilliantly strikes a perfect balance here. Together, they ensure administrative control while preventing tyranny, ultimately guaranteeing both fairness and efficiency in our governance.
Before we wrap up, I leave you with this final academic question to ponder. If the doctrine of pleasure ensures control, but exceptions can bypass their inquiries, does true constitutional fairness exist? Or does the executive always hold the final trump card? Reflect deeply on that balance of power as you conclude your studies for the exam. Master these provisions, structure your answers exactly as I instructed today, box your citations, and you absolutely will achieve top marks. Class dismissed.